but there are things that we need to deal with, because if they do not, the court's going to get involved, and the court most likely will appoint someone that they do not want administering their estate.
So is that part of the motivation? You say, look, if you don't address these things, some judge or court or legal authority who doesn't know you, your family, background, history, your priorities, values, they're going to be making the decisions for you.
That's correct.
That sounds pretty scary. I don't think I know I would not want that for myself. How do you feel about openness? And I had a family situation where a relative of mine was looking to make a significant change in who they wanted. They're single. Was making a significant change in who they wanted to be the heir to their estate. Significant change. And they wanted to keep it secret and not share with the parties what was going on. And I don't want you to comment specifically on that because you don't know all the information. But in general, how would you typically guide your clients in terms of openness versus secretiveness as to the planning that's being done and who ultimately might be in decision-making authority if there's a crisis, or be a beneficiary, inherit money from a person or a family?
And I know everyone hates this word from an attorney, but it does depend. Everyone hates it.
But that's good. We're about 15, 16 minutes in and you haven't said it before. That's why I had you on. I mean, you're the best. So, all right. So it depends. So it depends on what?
It depends on the client's capacity. If we're dealing with a marginal capacity client, we're going to want to get outside parties involved.
Okay.
If I'm dealing with someone in their 60s and 70s, they clearly have no issues, no capacity issues.
Right.
They're going to stand up. They can write out their expression of their wishes on the paper where I can get that into a document. It's not an issue. But what we need to do is get their representative, and that could be a family member, a friend, it could be an organization like your organization or the law firm. We need to make sure that they're involved so they understand that if something happens, they're going to be able to get ahead of the family's ire.
Right.
It's not uncommon. And I know people come in all the time and they say, you've probably never heard this before, or you're probably surprised I'm disinheriting my children. And I'm not surprised. We probably disinherit over 10 children a week. It's not uncommon. But we just need to make sure, part of the estate planning is to make sure that the estate's not going to be contested and that the representative's not going to be held up for years.
Okay. So we focused on a little bit of like the money part of things and avoiding probate cost and making it easier. But now we're touching a little bit more on the family social part of things. Is it fair to say that proper planning, somebody that sits with an elder care attorney, spends the time and the money to do things right and think through what they want and try and think through the various contingencies, sets up the family for less strife in an emergency or upon someone's passing? Because there's a lot of fighting over money and stuff after someone dies. And sometimes there's bad actors, but sometimes it's just, I thought mom wanted this, and the other sibling thinks, no, mom wanted that. And they have the noblest of intentions, but it could devolve into just an unbelievable family feud. So isn't part of this planning, I'm answering my own question, isn't part of the planning you do not just financial and not just to keep the courts out of it, but also to help keep the peace family-wise? Can you talk about that a little bit?
100%. So one question we're going to ask, do we want one or two family members to serve as representatives? As an example, if someone has two children and they get along even fairly well, it's better to have both of them. Now, if we have two children and they've never been able to get along, they've never been able to agree on anything, it may make sense if one of them is, as an example, a CPA, if she is a CPA or a licensed attorney, it may make sense because they have an obligation. They can lose their license if they don't follow the person's wishes. But often, if we have a situation where we know there's going to be strife, that we're going to look at a third-party administrator. Yeah, they're paying a small fee for that, but it will avoid a lot of headache for the family.
Okay. And even basic things like, you know, what the house that the children were raised in, what you would want to have happen to the house. If the parents don't tell the children don't really know what the wishes are because it hasn't been planned for, put in writing, and then there's the unknown that often could lead to stress for...
I'll give you a couple of examples. People think about the home and accounts, but it's really over almost things that you would consider ridiculous. We had a family fight over a vacuum cleaner and spent thousands of dollars over a vacuum cleaner.
Really?
I've been deposed and had 4 attorneys sitting around the table, people fighting over medals, military medals. And I'm not downplaying medals, but they had no really monetary value.
Right.
And so it's so important that we've dealt with those things. If there's a family member who's sentimental, we'll make sure that they're getting a specific item. The interesting thing is most of the disagreements come from outside, usually daughter-in-laws or son-in-laws who now think they want mom-in-law's ring, as an example.
So then the importance in part of doing this estate planning is to let everybody know to the largest extent possible what your wishes are when you pass away, so that there's less likely to have this kind of dissent in the family. It still might happen, and it probably still does happen, but it's better than just having it be a complete blank slate for anyone to interpret anything they want after the fact. All right.
And to give you an idea of that, the documents are very clinical. It's an expression of someone's wishes, but we also provide what's called an end-of-life planner. It's a 21-page form that goes through essentially any type of end-of-life consideration. So if the client would like to express their wishes or deal with something that they know will be a sore topic later on, it's a good place for them to write out the expression of their wishes.
So through this conversation, it makes complete sense, and I would think the listeners are, all right, I need to do estate planning. It might be basic if I'm, younger, might be more evolved as you become more affluent, as you become older, if you have complicated family issues. It makes complete sense. But why don't people do an estate plan? There's lots of people that don't do it or don't review it. Why do you think that is? Are they afraid? Are they ignorant? Is it procrastination? Is it what you talked about, confronting your mortality? Why don't people do something that is obviously in their best interest and their heirs' best interest? Because nobody likes to pay taxes. Nobody really wants to get involved in the courts. So, these are all things people go out of their way to avoid, but in this instance, they often don't do what is in their best interest and their extended family's best interest. So why is that, in your opinion?
Well, as you touched on it, one, they don't want to deal with their own mortality. One, they don't think they're going to ever die. And that's reality. Second, they're worried about the fees that are going to be charged. And then they're going to not know if they can provide the answer. We have so many people saying, I just don't know what to do. And that's the thing I'm asking, and I give them easy questions that they can answer, that they have to go home and consider, all right, if my minor child is left without a parent, who's going to serve? Who's then going to be the custodian to make sure the guardian's dealing with that? But it's something that, one, again, because they don't think they're going to die, and then they're having to look around the family, and the family may be flawed. Who do they appoint?
Aren't all families flawed?
Every family's flawed in some way.
So part of it, you think, is just a reluctance to spend the money, aside from the other reasons that I said. One of the phrases I've begun using quite a bit that I stole from somebody else, so I did not coin the phrase, is it's easier to prevent a problem than to solve one. And that also applies to, it's less expensive to avoid a problem than to solve one. And so I don't like to pay attorneys. I don't like, I'm cheap like everyone else. But if you pay for valuable service, you're saving your family, your estate, your heirs more money and anguish. It's money that's well spent. That makes sense to me.
Absolutely.
Yeah.
Well, as an example, if you were doing a full estate plan, you have someone in a decent estate or addressing every issue, they could end up paying around $1,000. But here's the thing: if someone passes away and they don't have an estate plan, the fee that the state's going to allow the attorney to receive, it's a statutory fee, is up to 2%.
Okay.
Sorry, 2% of $1 million is $20,000 versus $1,000 at the most they would have paid the attorney to set up the entire plan and to make sure that their wishes are followed.
Okay.
So, like you said, the pre-planning is not for them; it's for their family.
Right. Okay. And so, when is it too late to do estate planning? We talked about millennials getting started earlier, and we're talking somewhat clinically about, okay, you move to a new state, you're healthy, your wife is healthy, and so you're going to do an estate plan, and that's all well and good, and it's super important. But people do procrastinate and not get it done. But then there's a crisis, something happens, there's a significant change, maybe health-wise, maybe somebody passes away, something happens with one of their children. So when is it too late to come see an elder care attorney and to devise an estate plan?
As long as someone is able to understand the legal implications of their actions and understand what the plan they're putting in place, it's not too late. But we'll have people that will wait where someone's in hospice or someone is in a nursing home, a skilled nursing facility, not just for rehab, but permanently. In that case, it's usually too late. And that's when the state's going to impose their own rule, and it's usually not the rule that the family would have wanted.
Okay. So there is a point when it is too late.
Right, yes. So when the attorney and then the notary are to the point where we understand the person's not going to be able to understand the legal implications of their actions and the plan that we're putting in place, then it's too late.
Okay. You mentioned power of attorney.
Mm-hmm.
I mean, and that's a really, really important document.
It's the most important document.
I mean, that's essential. If you could only have one thing, it's the POA.
Well, think about this. The power of attorney is the only document that comes into effect during the client's life.
Right.
Everything else is for the benefit of their family.
So how long does the power of attorney last? Because I am not an expert in this, far
Mm-hmm.
from it, but if let's say we did a power of attorney, and then is it good for a year, 3 years, 5 years? Like if I tried to take it into a hospital or a bank, do sometimes you run into problems? Is there a time limit on it, or an expiration date?
There's not really an expiration date. And Florida has a rule that a financial and medical institution must accept it or they can be held liable if they do not.
Oh, terrific. Is that common in many states?
I'm not sure. I just do not know. But periodically, Florida will make a change. So, as an example, the HIPAA authorization, the Release of Medical Privacy Law, come into effect April 2003. We had to update the power of attorney. Florida made a change in the law in November 2012, and it's recommended, not necessarily mandatory, but strongly recommend the power of attorney be updated. So that's why I always say we need to talk periodically at a minimum every 3 to 5 years, or if there's a change in family situation, just to make sure we can update those documents and make sure, again, our clients and their family are protected in every situation.
All right, great. Well, this was wonderful. I learned a lot, and I think I know a fair amount too, but I learned a lot. I think our listeners will get a lot out of it. And as far as estate planners go, you weren't terribly boring, so that's good.
I appreciate it.
Very exciting. So in closing, you have any other thoughts or advice or recommendation, anything we didn't cover that you wanted to cover before we let our listeners go?
One thing, and this could be a topic for another day, is a lot of people don't realize that if someone needs care in the home or assisted living facility, there are programs that will help contribute towards the cost of care.
Okay.
As an example, if someone's a veteran or a widowed veteran and someone's receiving care at home, the VA will contribute up to $1,500 a month towards the cost of care at home. $850 if it's a widow. If they go into a assisted living facility, the VA will contribute up to $2,100 a month. And then there's sometimes state programs as well. So people always think the cost upon someone's passing, but the time they really need to get an elder law attorney in place or talk to someone is if someone's looking to become incapacitated.
That's great. And that's another thing, going back to the cost and hassle of going to an attorney and thinking about flawed families, confronting your mortality, but these are not small sums of money you were throwing around. And if you could get it, access, just information to how you could get some help financially and otherwise, because you guys are immersed in this stuff, you're in a position to help clients in that way too. That's great. Well, Eric, thank you so much for joining me.
Thank you for having me.
It was terrific, and I think the listeners will get an awful lot of value out of this. So I want to thank Eric for joining me on today's Simply Financial podcast episode. Eric, it was great. I learned a lot. I think we gave some valuable information out to the listeners, so I appreciate you joining me. I also want to let the listeners know that I appreciate them joining us. Please check us out and subscribe to the podcast by going to iTunes, Stitcher, TuneIn, and other podcast platforms. I will be back with you on an upcoming episode very soon.
The views expressed are not necessarily the opinion of SagePoint Financial Incorporated and should not be construed directly or indirectly as an offer to buy or sell any securities mentioned herein. Investing is subject to risks, including loss of principal invested. Past performance is not a guarantee of future results. No strategy can assure a profit nor protect against a loss. Please note that individual situations can vary. Therefore, the information should be relied upon when coordinated with individual professional advice. The information being provided is strictly as a courtesy. When you link to any of the websites provided here, you are leaving this website. We make no representation as to the completeness or accuracy of information provided at those websites. Nor is the company liable for any direct or indirect technical or system issues or any consequences arising out of your access to or your use of third-party technologies. Websites, information, and programs made available through this website. When you access one of those websites, you assume total responsibility and risk for your use of the website you are linking to. Securities and advisory services are offered through SagePoint Financial Incorporated, member FINRA, SIPC. Insurance services offered through Elliott Wealth Management, LLC are not affiliated with SagePoint Financial.